Hey guys, welcome to this video. This is John Watts. We're going to look at a case decision that came from the Middle District of Georgia just about a week ago, April 9th. And some of these case decisions we look at are very, very lengthy. This is not. This is very short. And I want to show this to you just really for one purpose. So let's look at this. This involves the Fair Debt Collection Practices Act. And so the facts are in yellow. Plaintiff discovered the defendant, who's a debt collector, reported two debts on her credit report. Plaintiff sent a letter disputing those debts, which that's entirely proper. And then the plaintiff claims the defendant violated the FDCPA, the Fair Debt Collection Practices Act, when it responded to her dispute letter. Notice the date, May 24th, 2018. So you have 1 year to bring a lawsuit for violations of the FDCPA. So the plaintiff brought a prior action, in other words, a previous lawsuit against the defendant debt collector based on those alleged violations. But here's the problem in light blue. But the court dismissed that action for failure to prosecute and failure to comply with the court's order after plaintiff, despite many opportunities, failed to serve her amended complaint on the defendant and did not show good cause for her failure to do so. So when you bring a lawsuit, you have to serve the other side. We talk about that no matter what type of lawsuit it is. Trucking case, a debt collection case, an employment case, doesn't matter. You have to serve the other side, the defendant. Well, you might serve them, and then if you amend the complaint, you have to serve that on them, okay? And they didn't do that. And the court evidently said a bunch of times, look, I need you to serve the defendant. And the plaintiff, according to this, did not do that. And so the court dismissed the case. Now, that would be a dismissal without prejudice. So it's as if you never filed that first case. So remember this date, because that's the important date. So then we have the new lawsuit is filed on October 28, 2019. But look, the violation occurred on May 24, 2018. That's more than a year. And so the second lawsuit that this opinion is on asserted the same FDCPA claims raised in the dismiss action based on defendant's May 24, 2018 response. So in the light blue, here we have the defendant. They're saying, look, you missed the statute of limitation. There's a 1 year statute of limitation. So here's the quote from the law. An action to enforce any liability created by the FDCPA may be brought in any appropriate court without regard to the amount of controversy within 1 year from the date on which the violation occurs. So it's too late. The judge says, I'm granting this dismissal. But here's the plaintiff's argument. She says, look, I know I filed it more than a year, but I should be protected by something called the doctrine of equitable tolling. Now, what is equitable tolling? That's where, in essence, it's like the statute of limitations sort of freezes for you because it would be unfair otherwise. So here's what the court says in the light blue. But equitable tolling is only appropriate when the movant, that would be the plaintiff, the consumer here, untimely files because of extraordinary circumstances that are both beyond her control and unavoidable even with diligence. So has to be something that I had no control over, and if I had been very, very diligent, I still would have been hit by this. Okay. And cite some law here. Plaintiff who has a burden to prove did not establish any extraordinary circumstances and did not establish they were unavoidable even with diligence. And notice what the court says, again in the light blue. Rather, the circumstances were entirely within plaintiff's control. If plaintiff had simply acted with reasonable diligence and served defendant with the amended complaint, either on her own as the rules require or in response to one of the court's several orders to do so, that action would not have been dismissed, and she would have been able to pursue her claims against defendant in that action. And remember, that first action was definitely filed within time. Equitable estoppel does not apply. This action is dismissed because it was filed too late. So I show this to you for one main reason and then a secondary reason. The main reason is if we ignore court orders, if we don't follow the rules, particularly when the judge says, hey, you're not following the rules, I'm telling you, start following the rules, your case can go away. Well, if your case goes away, then you may be outside the statute of limitation. I'm not sure if it says in here, yeah, I'm not sure when the order was, but it probably was more than a year after the violation of the law. Okay. And let's see, there may actually be, okay, yeah. So here's the prior history. Let me highlight this here. So the case was dismissed September 6, 2019. Well, that would have been more than a year from this date, the date that the violation occurred. So at that point, the plaintiff's out of luck. Okay. Now, they're trying to use this equitable estoppel, but this gives us some ideas of when equitable estoppel can be used. So it's extraordinary circumstances beyond your control and unavoidable even with diligence. So again, the lesson from this is pay attention to the court orders. These things are real. I mean, we have to follow them. And if we're trying to use equitable tolling, we better have a really unique circumstance where it's beyond my control and it would have happened even with me using diligence. So hope that that's helpful to you. If you want to read this, I'm not sure if this is on Google Scholar yet, but you can certainly check it out on Google Scholar, and it will probably appear at some point. Not an earth-shattering decision, nothing new here. It's just a very recent case that's come out. And I also wanted you to see this just to show you that courts are still operating. I mean, look at the date here, April 9th, in the middle of, the pandemic and the shutdown, but the courts are technically still open, at least federal courts, and a lot of state courts are as well. So I hope you find that helpful and appreciate you watching this video, and I'll catch you guys in the next one. Okay, thanks a lot. Bye-bye.